Hello and welcome everyone. My name is Dan Alvarez. I am a principal and founding partner in Synergy Settlement Services. We are all grateful for you choosing to spend some time with us this morning or this afternoon, depending on where you are. But we're excited about the content that we have to present, and we're hopeful that you will find it useful in your practices. Synergy is an organization that was found in an effort to allow trial lawyers and their law firms to focus on what they do best. And we have spent the last 15 years compiling a group of experts that can handle all the issues that we're going to talk about today at the back end of your personal injury cases. Do so in a fashion that maximizes your client's net recovery and hopefully saves your law firm's time and money. With that said, we do have a pretty quick presentation today. It's well, a couple-hour presentation, but we're going to hit a lot of content, so we'll be covering it quickly. And in these 20-minute sessions, we'll be presenting on advanced lien resolution strategies, reasonable cost and huddle billing, the protection of Medicare's future interests and MSP compliance in general, as well as our final session on government benefit preservation and ethical issues that present at settlement. At the conclusion of our mini sessions, we will have a 40-minute Q&A roundtable with the panel. So please, if you have any questions, jot them down. We would look forward to addressing them at the end of the session. If we cannot get to your question during the session, we're certainly willing to address the issue offline. So with that, I will move to our first panelist. We have Teresa Kenyon. Teresa Kenyon is the attorney that heads the Synergy Lien Resolution Division. Like a lot of our experts, Teresa spent some time on the other side of the lien subrogation space as an employee of Rawlings. With Rawlings, she spent 8 years as a manager running their West Coast operations and in-house counsel, and certainly has a lot of experience and secrets that she'll share with us from the dark side. So we'll all benefit from her time spent there, and we at Synergy and our clients certainly benefit from that inside baseball knowledge and deploying that on the plaintiff side of the case. And we're glad to have brought Teresa over to the good team. So Teresa, with that, I'll hand it over to you.
We just did a trial run for sharing the screen, but I don't think that it's working. Let's see. All right, do we see this? Is that a yes?
Yes.
Okay, good. All right, excellent, because I cannot see anyone, so want to make sure. All right, so we are going to be talking about ERISA liens, FEBA liens, and military liens here today. So this is my bio slide. As Dan said, I was on the dark side. You know how things work over there, but ultimately I've got a great team of people that handle these liens and these files and bring them to resolution. We've got over 125 years of experience. Most of that is experience from the other side. So it's not just me, it's my entire team. So this is going to be our agenda. For ERISA liens, we're going to talk about self-funded versus fully insured. We're going to talk about the recovery vendors. Who are they and kind of what are they incentivized by? And then we'll hit the U.S. Supreme Court decisions. For FEBA liens, we're going to talk about preemption and then attorney's fees and made whole, how it applies to FEBA liens. And for the military liens, a little discussion about Tricare versus VA. Also, the third-party liability form, and then whether an attorney has a duty to these military liens, and then what kind of reductions are available. So that's just the high-level overview. Okay, so for ERISA liens, ERISA is the Employee Retirement Income Security Act. It's the minimum standards for retirement and healthcare benefit plans. So originally it was meant to provide protection for the individuals that are covered by these plans, but as it's turned out, it seems that it's more protective of the employers themselves, especially when it comes to these ERISA liens. These liens are either self-funded or fully insured, and that is based on the type of contract or policy that's held by the employer. So we'll talk a little bit about that here in a minute. So the first question is always, is the plan ERISA? And I often see some confusion just right here at the first question on whether it's ERISA or not. So ERISA is an employer-employee plan. That covers pretty much all employer-employee plans with a couple exceptions. So those exceptions are religious employers. Those are going to be subject to state law, and then also government employers. So it could be the city, it could be a county, it could be a state, or even a federal government employer. And those are going to be covered under FEBA, which we will cover here in a little bit. Government plans like Medicare and Medicaid are not considered ERISA. They are not employer-based. And then also individual plans are not covered under ERISA. They're not really through an employer, it's through an insurance broker or the marketplace, similar to the Obamacare kind of coverage. So the next question is it self-funded? Self-funded ERISA plans preempt state law. It's considered federal law, and really what that means is that the contract language, the policy language of that health plan is what controls the reimbursement rights. So for it to be considered self-funded, it means that the claims are paid with the funds that are contributed to the pot by the employer and the employee. So basically they have a separate bank account that they take premiums from employees' paychecks just the same, $50 a month, $300 a month, whatever it may be. And that money goes into a special pool that is just for the payment of the claims. These employers primarily then use health insurance carriers, so your Aetna, your Blue Cross Blue Shield, Anthem, and they are the claims administrator. So that means that they are responsible for paying the claims, but not actually funding the claims. The actual funding comes from the self-funded employer group. This is different than a fully insured plan. So for a fully insured plan, the employer collects premiums, just the same, $50, $300 a month, and they collect all that money and they pay it all to Aetna. And then Aetna is the one that carries the burden for payment of the claims, Anthem, Blue Shield, all the different companies. So that's the real distinction on whether it's self-funded or fully insured, and whether it goes by state law or whether it preempts that state law. And that's definitely an important distinction every time that you're approaching one of these liens. So these are the recovery vendors that we see most often, probably the ones you see most often as well. Optum and Equian have joined forces. We've also got Conduent and the Rawlings Company. Those are definitely the big four. Blue Cross Blue Shield has a lot of internal units. Just recently actually learned some special tricks about what makes Blue Cross Blue Shield keep it internal versus sending it to a recovery vendor like this. But basically, these particular recovery vendors, they are highly trained with very narrow arguments. I can certainly vouch for the Rawlings group. They've got a 3 to 6 month training process, and they are using form letters, they are using scripts and being told that if you hear this, you respond with this. And so a lot of times we see, and I'm sure you see the same, where you don't feel like you're getting anywhere. You're having these conversations with an analyst or an examiner. You think you're bringing great arguments, and it's almost falling on deaf ears. And that's by design. That is how these companies have trained their soldiers, if you will, to challenge these. They're also very incentivized by bonus. And it's not necessarily every single company incentivized by bonus in the same way. Some are by just closing a file, others are by the percentage of reduction. It might be the dollar amount of the check that you end up sending to them. Whatever the case may be, it definitely can make it more difficult for you to resolve that file. So for a brief overview of the U.S. Supreme Court decisions, I'm just going to jump to McCutcheon. It's the biggest one and the one that really carries the most weight. Basically saying that whatever that policy language says for an ERISA self-funded plan, that is the governing law of the health plan, and that equitable arguments can't override it. The key is that it's supposed to be clear language. So that's where my team really focuses on what the policy language says and the words that are used. Unfortunately, as I shared on the previous screen, these recovery vendors aren't trained to look for those little ambiguities and things that we might really capitalize on. So for us, it takes a couple of rounds before we really start to get traction and can get a decent reduction because of those issues that are inside that policy language. So just as much as they will use McCutcheon against us or against you as the representative for the injured party, we can use it against them just the same. I feel like I'm running long, so I'm going to skip a little. Regarding attorney's fees, this is my favorite line in the McCutcheon case that says that third parties' recoveries do not often come free. To get one, an insured must incur lawyer fees and expenses, and without cost sharing, the insurer free rides on its beneficiaries' efforts, taking the fruits while contributing nothing to the labor. Like I said, this is my favorite line that's in McCutcheon, and definitely something that falls on deaf ears when it comes to those recovery vendors. But this is something that we can use as a means for trying to get some equitable reduction for attorneys' fees. So the Montanil case is another case that often comes up. It's a very fact-specific case, but at the end of the day, it was because the Board of Trustees of the National Elevator Health Plan was non-responsive to the attorney who was trying to negotiate and settle the lien. And that attorney did his due diligence to try to get that negotiation underway, to try to get communication from the plan. I'm sure you have all had those situations as well where the plan is just not responsive, or they send a lien letter and then you send 5 more letters and never hear anything from them. Using the Montanil case as a means to solicit a response sometimes works. I can tell you that at the Rawlings Company, when this case first came out, they had a whole new policy and procedure on what to do if the attorney mentioned Montanil. New form letters were created and new scripting was created for that situation. So in this particular case, because the attorney did his due diligence and still couldn't get any response from the plan, the attorney went ahead and dispersed funds. The funds were spent, and then the plan came knocking, trying to get their reimbursement. And it was 6 months after that, and they filed a reimbursement action. The court ultimately found that because they were no longer identifiable funds, and it was spent on non-traceable items, that the lien was therefore no longer valid. So can definitely be a good case to use in those situations where you feel like you're banging your head up against the wall with a non-responsive lien holder. So for ERISA plans, what do you need to be able to really assess the plan's rights? You're definitely going to want the summary plan description. That's the policy language that the recovery vendors are going to give to you most readily. But you also want to make sure you're getting the master plan document. So that's the MPD. These are usually older documents. I just looked at one yesterday. It was from 2002. Meanwhile, the SPD is usually updated annually. So every year they're able to update it and close any loopholes that may have been discovered through previous lien negotiations. Maybe a court case came out in a particular area that made them realize that they had a deficiency, and they're able to close that up in the SPD. But the MPD, because it's the original document, the master plan, it doesn't change as often. And I believe when it does change, it kind of takes a big undertaking to get it changed. So when there's a conflict in those two documents, you've got some compromising and negotiating space. So the other thing that a lot of people request is the Form 5500, but then it often seems that it's misused or misinterpreted. Definitely can be a place though where you are able to solicit some compromise from the lien holder. You are looking to see if the box for insurance is checked, and you're looking to see on the schedules which benefit plans are listed. So there's a little bit of complicated nuance there, but if things don't add up, then you definitely have a place to argue for reduction, or even to argue that it's not even a self-funded plan and that it is indeed fully insured. One thing that's really important that I feel like people often miss when it comes to negotiating these liens is auditing that lien claim summary. There are oftentimes claims that are unrelated that are on there, that are arguably unrelated, but the more that you can decrease that original lien claim, the better you're going to be with paying less, obviously, for the lien. Seen a lot of problematic claim summaries that don't have ICD or CPT billing codes. The CPT code is really important because that's the procedure code. So often the ICD code can very generically say back, but then if you look at the CPT code, you can see that it's some kind of procedure to a toe. I've noticed a lot of the recovery vendors will not include CPT codes. That's a big problem. So you should be demanding that proper coding be listed on their lien summary. It is their job to support their lien claim. I've also seen where providers are not listed. It'll either say unknown or it'll just say medical. It'll be blank, just various things. Date ranges are a big problem. So anytime you see a lump sum that shows like a week's worth of treatment, a month's worth of treatment, even just 2 days of treatment, you're going to want to ask for that to be broken down by day. It goes along with the bundled charges, any kind of lump sum, you're going to want it to be broken down by CPT code so you can actually see what is inside of that big lump sum. And then finally, just really understanding the applicable law. So which law applies? Is it state? Is it federal? Is it a fully insured plan? Is it self-funded? If there are other states that could be involved, perhaps your client lives somewhere else, perhaps the accident happened somewhere else, lots of choice of law arguments can go into how this lien is to be resolved. All right, so that's the end of my ERISA section. It was the longer one of the three here. So let's flip into FEBA. So FEBA is the Federal Employee Health Benefits Act. It actually covers a lot of employees. It's considered the largest employer-sponsored health insurance with 9 million federal employees and retired people and their family members. Administered by the Office of Personnel Management, that's OPM, and they're the ones that negotiate the contracts with the private insurance carriers. So for these FEBA plans, you'll see the exact same health insurance carriers acting as claims administrators. You'll see Aetna and Blue Cross Blue Shield, Anthem, Health Net, Cigna, all the same. So there's two main cases. What's somewhat frustrating about FEBA is that there's not a lot of case law that's out there with these. ERISA, you see it pop up a lot more, which can create some loopholes and some guidance. FEBA, there's just not a lot out there. And really that just emboldens the lien holders to hold on to the preemption that does exist and to point to their policy language, which isn't as varied as ERISA policy languages are. So there are two main cases, the first one being in 2006, the McVeigh case. And in that case, the Supreme Court declined to exercise subject matter jurisdiction and said that any issues related to FEBA would need to be litigated in state court. So the issue focused on jurisdiction in that particular case. So that created some uncertainty as to whether state law or federal law applied, but there was definitely no clear distinction there. And then in 2017 is when we got the Coventry versus Neville's case. It had been trickling through the Missouri court system before it ended up with the US Supreme Court, and it was the final confirmation that FEBA plans do preempt state law. And in that case, the court actually referred to ERISA as an example of another federal statute that preempts state law and allows the contractual terms to control. So attorney fee reduction and made whole, those are obviously your two biggest equitable arguments to get a lien reduced. And this is the preferred policy language that allows some discretion that you want to be looking for in your FEBA contracts. If you've got a FEBA lien, they all do not have this. And even if they do have it, it doesn't mean that you're going to get much traction from the person handling the file, but it's definitely the first step in the right direction. So it does say that they won't reduce their share of recovery, so that's not good. But unless we agree in writing to a reduction because you didn't receive the full amount of damages you claimed, so made whole, or because you had to pay attorney's fees. So this is what you're hoping for in these FEBA policies, because otherwise they are pretty tightly worded, and it can definitely be difficult to break through to the recovery vendor that's handling these. Again, at Rawlings, I can give you some insight that they've got an entire team that is FEBA focused. That was a change that they made internally a couple of years ago. The FEBA plans were handled by everybody, and then they realized they wanted to specialize people and give them very narrow arguments, and they had much success with that. Once they did that, that team was the highest producing team there at Rawlings, simply because they were able to say, we don't reduce, we don't reduce. So they have been indoctrinated, that is for sure. All right, so turning to military liens, Tricare or a VA facility. Those are your two main places that you're going to get some interaction with military liens. So Tricare is the health program serving our uniformed service members, retirees, and also their families. So if somebody is injured and it's the fault of a negligent party, they're going to either get treatment directly at a VA hospital, or the bills from a non-VA facility are going to be paid for by their Tricare insurance. So sometimes there's a lot of confusion about whether it's Tricare or VA, but that is the main distinction. This is the legal starting point. It's the Federal Medical Care Recovery Act, the FMCRA. This is where it's stated that the United States has the right to recover the reasonable value of care from the person responsible for the injury. So in most cases, that's going to be the third party. Again, causes some confusion because they don't go after the third party in most situations. They're actually looking for reimbursement from the injured party. So this looks pretty duplicative. So one question that I get is whether there's a duty on the part of the attorney to actually place them on notice or otherwise make sure that they are reimbursed for any lien that they might have. And I'm not sure of any written requirement that says that there is a direct duty, but the beneficiary of the services, who is your client, does have a duty to cooperate in those recovery efforts. And really, it's the same for FEBA, it's the same for ERISA. I know a lot of times we hear about Medicare as the super lien, and we'll talk about Medicare in a later presentation here today. But at the end of the day, if your client has some kind of obligation to take care of the lien, it's always going to be in your best interest to make sure that you're trying to identify it and get rid of it on their behalf, whether that means getting a waiver or getting a major reduction. But leaving it hanging out there is where the problem is. So same with military. That's what we're going to say, is that notice should be given even if you haven't heard from them directly. And I would make that same statement for the other lien types as well. So this is just a screenshot of a form that is required to be filled out by your client when there is a third-party liability incident. This does have a 35-day deadline, or they can not pay the claims. I don't have a lot of experience with seeing that work out, but we do see this form being filled out and completed. And if claims haven't been paid, once this does get submitted, then we start to see some action there. This is another form that we see with the military. It's the Attorney Representation Agreement. This is definitely something that you all don't like to see. We'll see it a lot of times with unions or certain kind of trusts that want you to sign some kind of agreement saying that you're going to represent their interests. The most ridiculous part of that is that they want you to represent their interests, but they don't want to pay you an attorney fee for doing so. And the military is no different. So unfortunately, if you don't fill out this form, then you cannot get an itemized lien ledger. And without that, you're basically just getting a dollar amount saying that the military wants $20,000 for reimbursement, but you can't actually see the breakdown of what it is that they're including for that $20,000. So it's definitely a catch-22 here. If you have the ability to figure out what it is that's in their lien, or if it otherwise matches up, then you might be better off not signing this. But if you do need to see that breakdown, then unfortunately, this is kind of feet to the fire where it needs to be signed. So attorney fee reduction, that is always something that is talked about and desired for all of these liens, because it's a way to chop off a third or 40% of the lien payback. But in that form protection agreement that was just on the other screen, it does say that under the United States Code that they are prohibited for payment of a fee for representing the government. They're prohibited from allowing that, and that I'm going to read further. As the claim of the government is an independent cause of action rather than a lien on any settlement or judgment obtained by the injured party, any contingent fee arrangement with the injured party applies solely to the client's claim and not to the government's portion of the recovery. So that's their way of spinning out of paying an attorney fee, is to say that that their cause of action is actually an independent cause of action, and that they just aren't subject to the fee agreement that you have with your client. It's certainly something that any of these liens could claim just the same way, but unfortunately, this is actually written out in the code. So with that said, what reductions are possible on these kind of liens? Really, there are only two statutory reasons for reducing. The convenience of the government. So if it's convenient for them to reduce, then they will. And otherwise, the hardship to the beneficiary. So definitely clearly stated that it can't be a reduction for attorney's fees. And they have limited ability to actually compromise or waive, especially on the first round. So they have a kind of tiered system as far as how it progresses for reductions, but they will take into consideration hardship. So these are some examples. This is for the Department of the Army, but these are some things that they will consider for a compromise or a waiver. So the amount of the settlement funds. So obviously, if it's a very limited settlement, your chances are higher to get that waived or reduced. The value of the claim. So they do take a look at the value. That would be an all-board argument normally under Medicaid, but the Army will take that into consideration. Government benefits accruing to the injured party. So if there are other things that are assisting the injured party, then they'll take that into consideration. The amount of futures is a consideration as well. Financial hardship, so whether they have funds or whether they're homeless, is definitely something that they take into consideration. And then any kind of contributory negligence, they'll take it into consideration. It doesn't mean that they'll do any kind of direct reduction because of any of these things, but it's something that gets considered. So it's part of their compromise in general. But the big thing that they push back on us a lot is the attorney reducing their fee? And that's always such a hard thing for us to have to turn around and ask the attorney who has hired us to handle this, are you reducing your fee? But if you are, certainly share that with us, because passing that along can get us some goodwill on this particular case. And ultimately, at the end of the day, it's all about reducing as much as possible for the injured party. And that concludes my part of the presentation. This is 2019's reduction for liens. So I'll just leave this up while we pass off to the next person. But this is our average reduction, and it's they're looking pretty good. Over and out.
Thanks very much, Teresa. Excellent presentation. You covered a lot of great quickly. well done. That moves us on to the to the reasonable cost winning techniques to reduce hospital liens for our presentation, and I'm pleased to introduce Michael Walrath. Michael Walrath is another great Synergy team. Michael has dedicated his entire legal career to negotiating the reasonable value of hospital bills. He's a very sought after expert in this space. We're to have him on our team and servicing families that we perform with our attorney clients. So Michael, I'll hand it over to you.
Thank you, Dan. I hope that everybody can hear me okay. I was having a little trouble hearing Dan. And I hope that my screen is sharing correctly. I am happy to, I'm sorry, was that it is or it is not? Hopefully you guys can see my screen okay. I'm happy to be with you today. We are going to be talking mostly about hospital liens, but I wanted to point out at the outset that the principles here do not differ tremendously from other providers. And my team at Synergy handles both hospital liens and all other direct provider liens, which are usually the product of a letter of protection or some similar contractual agreement to create a lien against a settlement on behalf of a healthcare provider, oftentimes a surgeon or a surgical center, if not a hospital. As Dan alluded, I have been dealing with the reasonable value of healthcare my entire career, and interestingly, from a bunch of different angles. I began as the National Director of Litigation for the Fairness Foundation, which was a foundation that represented uninsured patients against hospitals to assist them in resolving their medical debt. Had the opportunity to litigate those cases nationally with a team of attorneys that resided in the various states. However, a lot of our litigation was in Florida, so I was able to handle that directly. From there, I moved on to managed care and was in-house counsel for a managed care company that assisted international insurance companies with U.S. healthcare claims, which, although insurance companies are treated much like self-pay patients because they don't have the benefit of managed care agreements, so I was litigating the reasonable value of healthcare or negotiating or contracting for reasonable healthcare costs for those international payers. From there, actually simultaneously founded a law firm dedicated to these issues, and now I am able to bring all of that experience to you all through Synergy, which, as you know, negotiates these hospital liens and direct provider liens rather than litigates them, and allows for your settlements to be enhanced and distributed, ethically. As with Teresa's presentation on some of those other lien types, oftentimes state law is very important, and you do have to follow that law, and that law differs. It differs by state, not only in the statutory sense or ordinal sense, but also in the way that those statutes and ordinances and contracts, if it's contractual lien, are interpreted by the state courts. So there's no federal regime here for hospital liens at all. It is purely state by state, and those states differ pretty widely. Florida has no state statute, but has ordinances that protect hospitals in some of their counties. We'll get into Florida in a little more detail later. 9 states have no hospital lien laws at all, and many hospitals, whether in a non-lien state or a lien state, create liens by contract on admission. So essentially, they've added language similar to your letters of protection into their admission agreements, and those agreements do create contractual liens. So they differ greatly. You do have to follow those law and facts. And as an example, I'm just going to run through a few of those differences. California, for example, does have a lien statute statewide, Statute 3045. All of you in California here today know that one well, I'm sure. It does limit the liens to reasonable charges or 50% of the proceeds. Interestingly, it does expressly say that the burden of proof is on the, actually, I take that back. That express requirement is in the case law in California, I believe, not in the statute. But there is a case directly about 3045 that says the burden of proof is on the hospital to prove the reasonableness of their charges, and we'll get into some of those strategies in a moment. Illinois, a little bit different, although also has a statewide lien and does limit it to the lesser of reasonable charges, or 40% of the proceeds. So there's no real rhyme or reason other than who lobbied better as to where these sort of arbitrary, what I'll call equitable provisions in these lien statutes come from. Illinois, only 40% of the recovery is liened, while in California, 50%. The lien rights in Illinois by statute cut off on the date of settlement. That's interesting and not in a lot of other states. And in Ohio, just to give you the other end of the spectrum, no statewide lien law at all. To my knowledge, and if anyone from Ohio is on the call today and can enlighten me, I would appreciate it, but I did a quick search and did not see any county ordinances either. So I do not believe that there are statutory or ordinal liens for hospitals in Ohio, but I could be wrong. Of course, you have to check for contractual liens. Contractual liens, anybody can create them, as you know, and if you're aware of them, and I recommend everyone become aware of them on each case, I recommend that plaintiffs' lawyers literally ask the hospital providers whether or not they are asserting a lien, and if so, to provide documentation, because finding out later after distribution is obviously a scary day. Another comparison, Florida. The Supreme Court in Florida has deemed most of our counties. I'm in Florida, by the way. I'm in Miami, so if I refer to our when speaking about Florida, that is why. The Supreme Court has deemed most of the county's liens in Florida as unconstitutional. So only 9 counties remain with valid hospital liens in Florida out of the 67 counties in this state. I'm sure we'll all be hearing a lot more about the counties in Florida over the next couple of weeks. But anyway, the ordinances do all limit those liens to reasonable charges. However, none of the ordinances take into consideration the amount of the settlement, unlike many states, as we just saw with California and Illinois. So as you can imagine, a reasonable hospital charge, even if that's much less than the full bill charge, which we'll get into, could exceed the settlement. And in Florida, under every county ordinance, which is still valid, those hospitals could take the entire settlement. No money for fees and costs to the lawyer, no money even for costs. Literally, the entire settlement could go to the hospital. So it is an interesting state and a difficult state to deal with these liens with certain providers, and worse in certain counties, of course. Texas, one of the few statutes that I've seen in the country which does not expressly limit the lien to reasonable charges. I find that significant because the entirety of my argument is based on reasonable charges, but it does have a few little nuances that help. It, like most states, does not apply to work comp, expressly does not apply to first party, to UIM, so that's helpful. Many times there's a component of your settlement that can be just excluded from this lien conversation altogether. But most importantly, the Supreme Court in Texas has somewhat recently created a reasonableness requirement for these liens, and that is significant. In fact, in my view anyway, from a litigation perspective, it makes Texas ripe for litigation of these liens. It does create a framework to build on. In fact, the Texas Supreme Court relied on some Florida cases, one of which was one of my opinions out of the second DCA, the Giacalone case, and that new Supreme Court opinion in Texas does give you the ability to argue reasonable value and to get discovery of some things that make the hospitals quite uncomfortable. And that, in my experience, dramatically increases the likelihood of settlement to about 100% because they're not giving you that information. Pennsylvania, again, I wanted to give you the other end of the spectrum, no statute at all. There are contractual liens. I have seen a few hospitals over the years that have created contractual liens. Thankfully, there is good case law in Pennsylvania on reasonableness. And so, again, a lot of it focused on discovery. And in my experience, again, that's where you win a lot of these cases, or at least where you make the hospital lose their appetite for litigating them. Last comparison, Maryland. Maryland is the last all-payer state in the country. And what that means is that hospitals charge similar rates to all of their patients, whether they're Medicare, managed care, or self-pay. basically not only charge, all hospitals charge the same to those patients. Maryland accepts payment of largely the same amounts from these three categories of patients. And what that does, how that's done is they have a commission that approves hospital charges as being reasonable. Obviously, that is a problem for me in negotiating these Maryland hospital liens. However, I've been pleasantly surprised in my time here with Synergy over the last few years that we are receiving very good discounts in Maryland, despite the fact that I would be reluctant to litigate the reasonable value in Maryland. Hospitals are taking into consideration our reasonableness arguments. So we've met with success in Maryland, thank God. The statute, it also limits hospital liens to workers' comp rates, which sounds fantastic to somebody like me who is in a lot of different states on this issue, because in most states that would be a windfall for the plaintiff. The work comp rates are very, very low. In fact, I use them to argue in other states what the reasonable value is of certain professional services. However, in Maryland, as best I've been able to tell so far in speaking to some of the people actually on the commission and other folks, workers' comp rates do equate to the commission rates, and the commission rates are essentially the full bill charges, so it doesn't help you like you would think. However, I'm not certain that all the hospitals understand that, and it allows us to make some arguments, or you to make some arguments, where you can request what the work comp reimbursement would be, and it's just another thing that they have to do, which creates pressure, and sometimes that's all you need in order for them to reduce. Wisconsin, they do have a state statute. It limits the liens to reasonable charges, but after fees and costs. So much like some of the ERISA and FEBA arguments that Teresa was describing, that is a chunk of money that you can essentially carve out of this discussion, which is helpful. The Wisconsin statute applies only to charitable hospitals. So far, all of the hospitals that I have dealt with in Wisconsin are charitable hospitals, so that hasn't helped me. I presume there must be some private hospitals in Wisconsin as well. And perhaps they're just simply not as difficult to deal with because they don't have lien rights, and so we haven't seen them. But always check in Wisconsin whether or not your hospital is charitable or private or for profit, because they do not have a lien unless they're charitable. Liens don't attach to work comp. That's normal. The language, however, in Wisconsin, to me anyway, and I'm arguing this issue currently on a large lien in Wisconsin. They do not apply to wrongful death recoveries either. That is arguable everywhere, as you can imagine, because it would be very difficult to apply one person's medical bills as a lien to another person's damages. And if it is the person who is injured who also is the recipient of wrongful death damages, as is the case I'm working on, for example, a mother who has lost a child, but was in the same accident, was also injured, also has a hospital lien, that distinction becomes very important because of the allocation of the settlement. If the wrongful death allocation is larger, the lien would only reach the PI damages. Virginia, as my last state, just to talk about in this comparison, has a very interesting and unique situation where it has two different statutes, one for private hospitals and one for Commonwealth hospitals. The private hospitals liens are limited to $2,500. That is amazing. However, remember, that is only the lien. There is a difference between a lien and a debt, a very important difference. And it really comes down to your ethical requirements, and your ethical requirements in every state are to protect the liens. They are not to protect the debt. If your client has a debt that is not attached to the settlement in some secured sense, like a lien, then it is up to the client whether or not they want to pay that hospital debt out of their settlement. So private hospitals in Virginia, you can pay them the $2,500. So long as they will agree that that is payment in full on the lien, they can then pursue the debt balance through traditional collections. The Commonwealth hospitals are different. That lien statute, very similar to Texas, doesn't limit it doesn't expressly limit in a very clear way to reasonable charges. However, there is an argument to be made where elsewhere in the statute they reference reasonable charges as part of the enforcement procedures in the lien statute. And so I argue that there is reasonable limitation. However, the AG's office handles those Commonwealth liens. They do not see it the same way I do. It's something that I have always wanted to litigate there in Virginia, have not had the opportunity. But the AG's office is very difficult to deal with on fully funded settlements. In Virginia, we've had limited success with those. However, they're somewhat easy to work with on limited settlements, on settlements where you're trying to break up the settlement on an equitable basis. So I want to talk quickly about reduction strategies, and I'm going to pick up the pace here a little bit. Forgive me for rushing, but I'm sure that I'm over time already. Reduction strategies, how do we get these reductions that I keep referencing? Well, important to take a look at what you're doing now. Currently, what I see usually is basically a blind negotiation, a negotiation about the billed amount, starting at the full bill charges and negotiating down, negotiating for what everyone, including the plaintiff's lawyer, unfortunately refers to as a discount. I try so hard with my team of negotiators and myself to be disciplined about that word. We are not looking for a discount because the full bill charges are never owed. That is just a farce, and it's something that the hospitals use to their advantage. They give you these astronomical numbers which nobody pays, and then offer a discount which is completely illusory. Oftentimes, plaintiffs' lawyers are willing to accept, obviously the best discount they can get. I see 20% and 30% commonly. And I start all of my live presentations by asking folks who are attending, what kind of results are you getting? And I hear oftentimes they won't accept less than 20%, 30% is average, and if they can get a 40%, again, discount, that is a home run. If that sounds familiar to you, you are in right in the middle of what I'm hearing, which is not a bad thing. But is there a better approach? I like to think there is. I think that better approach is to negotiate up from the reasonable value instead of negotiating down from this illusory full bill charge. I call this inverting the argument, and basically it requires you to first define the reasonable value, which I define as the cost of care plus a reasonable profit. Use that definition to determine that reasonable value and negotiate from there. You can determine the cost of care for hospital bills through the hospital's self-reported cost data. Every year, every hospital in the country which accepts Medicare, which is essentially every hospital, they have to submit to the federal government under oath a hospital cost report. It's a many hundreds of pages long report that goes through every single cost that hospital incurs in treating its patients, and then it allocates those costs to the various revenue centers or departments. That data can be used to determine the cost of care of your specific bill on a line-by-line basis. It's quite effective. Once you do that, you'll see that, and I add a 40 to 50% profit above cost, because I've had experts testify, and experts have testified before Congress on numerous occasions that 50%, that 40% is a reasonable profit above cost for a hospital. I actually typically give a 50% profit margin above my cost estimate. And what you normally see is the reasonable value, as I calculate, is going to come out somewhere between 20 and 30% of the full bill charges on most hospital bills. So when you use that inverting the argument, how does it compare to the typical full bill charge negotiation? I wanted to look at an actual case where we had a bill of $95,000, and in a traditional blind negotiation where you're just negotiating for a discount off of that amount, a 20% discount would be about $76,000, a 30% discount around $66,000, and a 40% discount, which, as you'll recall, most folks say, hey, that's a home run, resulted in a $57,000 bill, which, when you look at the cost of this particular bill, was a 344% profit, obviously much higher than I would say is reasonable. So if you take that same bill, and now with the benefit of our analysis or your analysis, we estimated the reasonable value to be approximately $20,000. Remember that means the cost plus 50% was around $20,000. I then negotiated up from that amount. Now, if you were to take steps and negotiate up, 25% above reasonable value would be $25,000. That'd be a 74% discount. 50% above reasonable value would be almost a 70% discount, and 100% above reasonable value, if you really literally double the reasonable value, you're still at a 60% discount. So that case, at the end of the day, well, I should say at the beginning of the day, the hospital had offered a 30% discount to the plaintiff's lawyer before we were engaged. So they had offered to accept $66,000 or so. We ultimately ended up settling the case for 50% above the reasonable value, which was $30,000. And even with our fee, which is 15% of that additional $36,000 in savings, The net additional savings to the client was $31,000. So that means that by hiring us, the client settlement increased by $31,000, which is why we always say that Synergy is never a cost to your clients. It's always a savings because there's no fee if we don't get one. The way I argued it is the way that I've roughly described here, and it's the way I argue all of these cases nationwide. We identified first and removed any billing errors, non-billable charges. We then calculate the cost of care on the specific bill, line by line. We then add a 50% profit above cost, make sure to put that into the framework of the existing law in that state or county in the case of Florida, and some counties in California have specific county liens as well. And then we basically make an opinion on what is the reasonable value of the care based on the hospital's own sworn data, and we use that to level the playing field. We never, and I recommend you never, rely on full bill charges as the only relevant data in these negotiations. So to conclude, you're always going to see a net savings, or there's never a fee. Fees are usually passed along to the clients as agreed costs, which means that the lawyers do not pay for these services. And I want you all to know, and if you can take note of, I'm happy to get you this information some other way as well, but please know that you can call me anytime, you can email me anytime. I'm happy to answer your general questions about how we do what we do, or even your specific questions about liens you're facing. So I appreciate your time, everybody, and thank you for attending. I'm going to pass it along to the next presenter.
I'm hopeful that my sound is a little better than the last intro. If so, I'll continue. Apologize if it sounded like I was speaking to you from the bottom of an aquarium. Hopefully that issue is resolved. I'm now going to be handing it over to Rasa Fumagalli. Rasa is an attorney with years of experience in the Medicare compliance space. She is a recent addition to Synergy, and we're very grateful to have added her years of Medicare compliance experience to our team. She's going to be speaking to you on addressing Medicare futures, addressing conditional payments, and Medicare Advantage liens. Rasa, it's all yours. And she joins us from Chicago, by the way. I failed in recognizing people's hometown. Rasa's joining us from Chicago.
Thank you very much, Dan. Let me just flip over to share my screen. I do seem to have a bit of a technical issue here. Okay. Is my screen showing? Is my screen showing?
Oh, it went away.
It is not. Okay. Okay. Is it showing? Okay, great. Thank you. Okay. Great. So as Dan mentioned, I am from the Chicago area. My background is, I must confess, workers' comp insurance defense. I have practiced in that field for over 20 years, but I've spent the past 12 years pursuing Medicare secondary payer compliance types of issues in a variety of different cases. So when I joined Synergy, I was hoping to be able to use my Medicare secondary payer compliance experience on behalf of plaintiffs and plaintiffs' attorneys to help ensure that plaintiffs' attorneys are able to protect their clients while considering Medicare's interest. So as you can see from this slide, Synergy has a wide variety of MSP compliance services. We are able to assist with conditional payments, with future medical allocations, structured settlements, administration, and many different types of lien resolution services. So when we're talking about futures in terms of Medicare secondary payer compliance and liability cases, people get very hung up on the fact that there aren't any specific liability reference guides that are similar to the workers' comp Medicare set-aside reference guides. And by pointing to this absence of a specific guideline or regulations, you're overlooking the fact that any obligation under Medicare is going to come from the Medicare Secondary Payer Act itself. And the language in the MSP Act is very clear. You know, as you can see, it specifically states that Medicare cannot make payment when payment has been made or can reasonably be expected to be made. And it identifies workers' comp, automobile, liability insurance policy, or no fault insurance plan. And so everybody pretty much understands that if payment has been made prior to settlement for medical services, that conditional payments must be reimbursed to the Medicare Trust Fund. But when you look at the first 3-4 words, payment has been made, that also addresses a situation when you have a liability claim where you are claiming a physical injury, of course, where you're going to need future injury-related treatment, and your settlement factors that into the whole settlement demand. In that particular situation, by virtue of accepting the settlement agreement, payment has been made. And this is the area where the potential obligation for future medical kicks in. So as I mentioned, Medicare can make payment when payment is not reasonably expected to be made promptly within 120 days of receipt of the claim by the primary payer. So this is the conditional payment piece. What is important to know about this is that payments that have been made under a Medicare Part C plan are also considered to be conditional payments, which have to be reimbursed to the Medicare Trust Fund, even though they're actually slightly different. 42 CFR talks about exclusions from Medicare and limitations on Medicare payment. This specifically once again states that the Act precludes Medicare payment to the extent that services or payment has been made under workers' comp, liability, or no fault. This section right here, 42 CFR 411.22, talks about how Medicare determines whether there's a reimbursement obligation. And the way that they look at it is by the fact of a judgment, a payment conditioned upon the recipient's compromise, waiver, or release, whether or not there's a determination or admission of liability of payment for items included in a claim against the primary payer or by other means. And so that second provision right there, which talks about a payment conditioned upon the compromise, waiver, or release, is one that plaintiffs' attorneys must be extremely mindful of, because your settlement terms are going to essentially outline what the scope of Medicare's secondary payer status is. So if you are specifically releasing a low back injury, Medicare's position is going to be that Medicare is secondary to any future injury-related treatment pertaining to the low back. So even though you might think it's a great idea to try to sign off on a release that excludes almost every single body part, you are really not serving your client well by having these overly broad releases. So essentially, there are 3 obligations under the MSP Act. There is the obligation to reimburse for conditional payments which were made prior to settlement. There is an obligation to avoid a cost shift of future injury-related expenses to Medicare. And the Section 111 reporting really is an enforcement mechanism. So the obligation to report under Section 111 falls upon the primary payer. So when you have a responsible reporting entity, which is going to be coming from the defendant in the claim, they're going to be obligated to report any liability settlement involving a Medicare beneficiary. And that is important because sometimes people think that any settlement will end up with Section 111 reporting, and that's really not the case. In liability, you have to have a current Medicare beneficiary, and the total payment obligation to claim it must exceed $750. And this is different from workers' comp, which has the ongoing responsibility for medical component, which would not apply to the liability cases. So the Section 111 reporting is also something that is done at time of settlement, and it is done for current Medicare beneficiaries by the primary plan. The beneficiary themselves, however, do have an obligation to report their settlement to the BCRC so that the BCRC may look to see whether any conditional payments were made, and they might reduce, and they should reduce, for procurement costs. We also can help having the entire conditional payment released essentially or discharged by making waiver requests or compromise arguments. So let's take a look at the lay of the land. We talked about the MSP Act a few minutes ago. Now let's consider what Medicare has actually been saying about liability MSAs over the years. So if you look at the progression of the CMS guidance memos and the different obligations that have been put out by Medicare over the years, you can see that they are definitely including liability as the type of a case that should have some Medicare secondary payer compliance issues with it. So in 2009, the Section 111 enforcement mechanism of mandatory insurer reporting kicked in. In May of 2011, CMS had a Stallcup memo that was put out in Region 5, I believe. It was Sally Stallcup had been asked to address whether a liability settlement should have the same sort of Medicare concerns as a workers' comp settlement. This memo clearly identifies that the law requires that the trust fund, the Medicare trust fund, be protected from payment for future services, whether it's workers' comp or liability. There's no distinction in the law. And even though, there's really nothing that mandates a specific mechanism for protecting Medicare's interest, this memo indicates that a set aside is the preferred choice. The next significant guidance memo that came out was in September of 2011. And this specific guidance memo talks about when a beneficiary may show that they don't have to do anything in terms of a liability MSA. And the guidance memo indicates that when you have a situation where the beneficiary's treating physician certifies that all the medical treatment related to the injury has been concluded by the time of settlement and that no future injury-related care will be needed, there is no need for a liability MSA. So if you kind of take that argument in the reverse, by virtue of the fact that CMS is saying that in this specific fact pattern, you don't need to do a liability MSA. If you look at the Medicare Secondary Payer Act, the Stallcup memo, all of these factors support the position that, well, they do believe that you should be doing something to avoid a cost shift of injury-related expenses to Medicare. So in 2013 and 2014, you had CMS decided to try their hand at proposed rulemaking. And they were unable, after putting out, 7 different propositions, they were unable to reach agreement on what to do, so they withdrew this rulemaking business. So you do see that the history of the Section 111 total payment obligation to claimant reporting thresholds over the years have required that smaller and smaller settlements be reported by Medicare to Medicare. So it started out in 2012 where liability carriers had to report settlements that exceeded $100,000. From January of 2017 to the present, you only have to report a settlement that is $750. So more and more of these liability settlement cases are subject to mandatory insurer reporting under Section 111. You then have some cases that came out over the years which addressed Medicare secondary payer compliance issues in regard to future medical. We have Starrett versus Klebart, which talks about the state court approving a settlement. You have Benoit versus Newstrom, which talked about equitable apportionment. And then there's Aranki, which states that there's no federal law that requires creation of an MSA. But even though no MSA must be created, what you do need is you have the obligation to consider Medicare's interest in every settlement. So let's take a look at what else CMS has been doing. So in July of 2016 and December of 2016, you had a request for a new workers' compensation review contractor. And even though liability MSAs were not being specifically addressed at the time, CMS wanted the new review contractor to actually have the ability to perform liability MSA reviews. You then had additional notice of proposed rulemaking, which was issued in December of 2018. This is a specific language of this current notice of proposed rulemaking for liability MSAs. It's talking about the proposed rule would clarify existing MSP obligations associated with future medical items, services related to liability insurance, including self-insurance, no fault insurance, and workers' compensation settlements, judgments, awards, or other payments. And you can see that this rule would clarify a Medicare beneficiary's obligation to satisfy Medicare's interest with respect to future medical. And this particular notice of proposed rulemaking was supposed to be rolled out several times, with the most recent version coming out in August, but really nothing has happened. This proposed rulemaking has been continued to be pushed out forward and forward. So if we take a look at other things that have been happening in regard to liability MSAs, there were several meetings that took place in Baltimore in the fall of 2019. And there were people there that were involved from, in terms of the MARC Coalition was there. There were other top MSP compliance professionals. And CMS has pretty much said that they are ready to proceed with a voluntary liability MSA review program. And the point of this is to protect the Medicare trust fund from premature depletion. And there was discussion that this obligation may also apply to beneficiaries that have a reasonable expectation of Medicare entitlement within 30 months. So kind of like the scoop, for lack of a better word, is that people really do believe that liability MSAs are solely going to fall on plaintiffs. And the responsibility does make sense, because if the plaintiff receives a settlement and the plaintiff is a Medicare beneficiary, Medicare is going to have notice of that settlement. They're going to have notice of the ICD-10 codes that were reported in connection with the settlement. And Medicare may very well deny future injury-related treatment, because if you look back at the MSP Act, payment has been made. And the way that this would affect a plaintiff is that Medicare would deny payment of injury-related Medicare-covered expenses up to the amount of the settlement, unless there is an apportionment within the settlement for future medical Medicare-covered injury-related treatment. And this doesn't mean that every settlement would require that. What every settlement should do, given the fact that the Medicare Secondary Payer Act talks about Medicare's secondary payer status in a liability case, is to address what Medicare's potential interest is with the plaintiff and in your case file, so that you can show that if there is ever a question about this, that you've properly documented your file. So what does this mean in terms of your handling cases? I mean, it would make sense for you to analyze your current plaintiffs. Do you have plaintiffs who are on Medicare or will be on Medicare in the near future? So, the worst case scenario would be a plaintiff comes to you and nothing happens in terms of addressing this Medicare beneficiary's potential issues with Medicare after settlement. And for example, if you had an $80,000 settlement with a shoulder injury, you can very well have Medicare deny care for that shoulder. If your client does not know of this potential risk, they cannot make an informed decision about this. And therefore, it's really a good idea to have this discussion up front. The plaintiff can then choose to either accept a potential risk with Medicare, or they might say that, I'd like to set aside something from my settlement for this. So what is it that you should actually be doing? Defendants are usually going to come up, if they choose to have this liability MSA discussion, they might propose a fully funded Medicare set aside. And that really is not necessarily an appropriate option. You might have a situation where your settlement does not fully fund any MSA. You might also have specific disputes and compromises in your settlement. There might be other ways of preventing a cost shift of injury-related expenses to Medicare. Other options are the certification from the treating physician. Defendant might actually say, why don't you sign a release that your client is not going to bill Medicare? And that would really be against public policy, but it's also not the best option. So there is really no one-size-fits-all approach that is going to work when it comes to Medicare in a liability settlement. You have caps on damages, you have pre-existing condition issues, and there are liability issues and policy limits, which is why this is so different from workers' comp. So what we think is a good idea to do in terms of future medical, issues and liability settlements is to either analyze the facts so that you can determine whether or not an MSA is needed to begin with, or if the decision is made, how to come up with the lowest MSA that supports your position that you have not attempted to cost shift any injury-related expenses to Medicare. So there are a few alternatives. If you think of the big picture, which is avoiding a cost shift of injury-related expenses to Medicare, if you have other health insurance that you're going to use for accident-related care, you are not going to be pushing any bills onto Medicare, and that is a reasonable alternative to this. There is also the option of the plaintiff just paying out of pocket or from their settlement proceeds when they go to the physician once they settle their case. You can set up a medical savings account, you can set up a settlement preservation trust, and you can purchase a structured settlement and have some of those proceeds be allocated or apportioned for future medical care. The key is that you shouldn't be settling your case with the expectation that my plaintiff isn't going to be submitting bills to anybody else. They're just going to push them onto Medicare. That is the wrong approach. So one of the things that you should consider when you first have a plaintiff is, well, is this person on Medicare, or will they be on Medicare at the time of the settlement of the case, or do they have a reasonable expectation of Medicare entitlement within the next 30 months of settlement? You should look at, is future accident-related care a possibility? You should also look to see whether the case actually funds future medical. If you have a situation where the settlement proceeds, because of policy limits or whatever the case may be, are insufficient to compensate the claimant for pain and suffering, to reimburse or pay back the outstanding medical bills, and after attorney's fees are deducted, essentially leave nothing, then this is a situation where no MSA would be appropriate because the settlement does not fund future medical. So protecting plaintiff's interests can be done by consulting with Medicare experts, by discussing with the plaintiff what the potential issues are with Medicare secondary payer compliance obligations, and documenting your file to make sure that everybody is on the same page. So there are different, disagreements as well in terms of your handling of the case with the defendant. If the defendant wants a liability MSA, but you do not believe it is appropriate, it's a good idea to have a discussion with an expert. You should also be mindful of what the settlement releases indicate. It's a good idea to agree on what ICD-10 codes are going to be reported to Medicare under the Section 111 mandatory reporting obligation. If you have a situation where you have a specific fracture of the patella, you want to report an ICD-10 code that is limited to that specific code. You do not want the defendant, through their responsible reporting entity, to actually be reporting something that is knee pain. Because when your client actually goes in for treatment for an osteoarthritic knee condition, your code is very limited, but the Section 111 code would be so very broad that Medicare may very well deny any payment for the knee. So we do have a MEC consult, which is one way to discuss these potential Medicare secondary payer compliance issues with your client. It involves a consultation. We determine what sort of settlement is going to be reached. We discuss whether a MSA waiver would be appropriate, or if no MSA is needed because the settlement does not fund future medical, or if there is an opportunity to secure treating physician's certification. If we determine by agreement that this is a case where the settlement is going to fund future medical is needed, we have a certified nurse allocator who would prepare a Medicare set-aside recommendation for this. Now, the next part that I'd like to talk about now just deals with conditional payment reimbursement. And conditional payments cases, there are many that have been litigated in terms of, oftentimes you actually see plaintiffs' attorneys thinking that a conditional payment that is an interim figure is a final figure, and they rely on it. And rather than using the administrative appeal process through Medicare, they're going to try to challenge the conditional payments before the district court or the circuit court. And so it's really important to know that there are many very specific things that you should consider when you're talking about conditional payments. Now, Medicare can recover the conditional payments from far too many people, which is why everybody is aware of this conditional payment issue. So Medicare can seek reimbursement from the primary payer, the beneficiary, an attorney, the provider, supplier, physician, private insurer, and so forth. So because of the fact that Medicare has an independent right to pursue conditional payment reimbursement from all these people, people are paying attention to conditional payment reimbursement obligations. And so when we're talking about traditional Medicare Part A or Part B, we're talking about the fee-for-service payments that Medicare has made to providers. And you would report the case to the BCRC when your plaintiff, and this is something that we can assist with as well, actually has an injury, they filed a claim, or they're contemplating filing a claim, and they're going to the physician for injury-related treatment. And so Medicare will then issue a rights and responsibilities letter, sort of putting the plaintiff on notice that you have to tell us when you settle your case, what you settled the case for, and then we will let you know what you have to reimburse us for. And as Teresa mentioned earlier, and I believe Michael did as well, a lot of times you're going to see things on these conditional payments or lien reimbursement payment sheets that really have nothing to do with the injury which is being settled. So it's very important to actually review these payment summary forms and dispute any unrelated charges. Once the case fully settles and you have a Section 111 total payment obligation to claimant report to Medicare, Medicare is going to do this final conditional payment data sweep, and they're going to pull out a number that you can rely upon in terms of this being the final figure. As I mentioned earlier, interim figures which you receive from Medicare in terms of conditional payments are subject to change, and there is going to be this final sweep once the case fully settles, unless you avail yourselves of the final conditional payment process, which is available through the BCRC. So once you get a demand from Medicare in terms of conditional payments, interest is going to start to run. You have to take action. You can either pay the whole thing to prevent interest from accruing, and what you can then do is you can appeal the case. And so the interest is going to start from the date of the demand, but Treasury referral should not be made once you have actually put out an appeal or a dispute of the case. So now, and I apologize here. So I do believe that the request for appeal is not going to toll the interest. So interest is going to keep running, but you're not going to have any issues with the Treasury referral. So after Medicare receives the payment, if you do not have an appeal that has been presented, they're going to state that the lien has been reduced to zero and that the case is now closed. So there is another type of a Medicare plan which you should be aware of, especially if you have a case that has lasted for a few years. You might have a Medicare beneficiary initially enroll in traditional Part A or Part B, but as the case lingers in your office for whatever reason, they might actually switch plans. So you might have somebody who the next year decides to enroll in a Humana Part C or Medicare Advantage plan. After that 1 year period, they might then enroll in a Blue Cross Blue Shield Advantage Plan program, and so on and so on. So the reason why somebody would choose to enroll in a Medicare Part C plan is that you get everything in terms of traditional Medicare Part A and Part B coverage, plus a little bit more. So these plans, you cannot get their payment information through the traditional BCRC methodology. You do have to follow up with the particular plans to determine what, if any, payments have been made. And these plans are notorious for going against the beneficiaries and their attorneys as well in some cases, using the Medicare Secondary Payer Act as their recovery vehicle. Okay, so under the MSP Act, they can also pursue this double damages provision. And there are some cases out there that have decided that these Medicare Advantage plans have the same rights to recover from a primary plan as do the traditional Medicare Part A and Part B plans. There is a CMS memo which was issued in December of 2011 that specifically stated that Medicare Advantage plans have the same rights to recover as Medicare themselves. There have been a slew of cases. The first one was In Re Avantia, which came out in 2012, which addressed a similar situation and found that the Medicare Advantage plan was able to pursue private cause of action under the Medicare Secondary Payer Act to seek double damages. There's also the Humana Medical Plan versus Western Heritage case, which came out in 2016. This essentially indicated that Humana was able to recover double their lien amount, even though the settlement terms had indicated that the plaintiff would be responsible for reimbursement. What we have seen when it comes to conditional payment actions, we have seen an increase in Department of Justice actions pursuing firms for unpaid Medicare debts. So in addition to the enforcement mechanism of Section 111 reporting, the private cause of action cases, we are now seeing the Department of Justice actions where they are pursuing specific firms for failure to address conditional payments within the cases that their offices have been handling. And when you look at what the descriptions and the summaries are of these cases, it seems that usually there's a conditional payment demand which was issued. But for whatever reason, these conditional payments were not reimbursed. So you can see that in June of 2018, there was a settlement agreement reached between the DOJ and a Philadelphia law firm. You see March 2019, November 2019. The most recent one was in August of 2020 with a Harrisburg firm. And so that also settled with the DOJ. So if there are things that I would like you to take away from this presentation is that it's really important to look at your class of plaintiffs and you should identify the Medicare beneficiaries. They are the ones who might have potential issues with Medicare down the road. They're also the ones that you should talk to them about this. You should allow them to determine whether they would like to be proactive in terms of apportioning some of their settlement, if appropriate, for Medicare in order to avoid an issue with Medicare denying bills down the road. If they would prefer to see whether there are alternatives, whether there are different ways that they can plan to have other entities such as a different group insurance plan pay for future injury-related care, as opposed to pushing the bills onto Medicare, or what steps, if any, they would like to take. It's important to have this discussion with them, though, so that you can have an informed decision which is made. It is also beneficial for you to control the MSP process as opposed to waiting for the defendants to do anything in the claim. It's important to educate your clients on the potential risks. It's a good idea to retain your own MSP experts. And it is important to be proactive when it comes to the Medicare Part C liens and potential Medicare secondary payer compliance issues. Documenting your file is also critical. So at this time, I would like to turn the presentation over to Jason Lazarus.
Thank you, Rasa. Real quickly as we transition, transition into Jason's portion, I just wanted to mention this. This is our last content section that Jason will be presenting, after which we'll have a wrap-up panel where we will take a Q&A. So now would be a good time, if you have any questions that you would like addressed, to begin to just pop those questions into our text box here within the presentation. And we'll be able to use those to have further discussion after this portion. So Jason Lazarus will be presenting on government benefit preservation and ethical issues at settlement. Jason is an attorney and the CEO of Synergy Settlement Services. In addition, as of 2 months ago, Jason is a published author. He has published the book, The Art of Settlement, which addresses most of the things we've discussed today, as well as a plethora of other issues that present themselves at the end of a complex personal injury case. And with that, I will hand it over to Jason.
Thank you, Dan. Can you guys see my screen? Good deal. Well, so I've got the pleasure of talking about a topic that I wrote extensively about in the book that Dan mentioned, and it's one of those things that I think most lawyers overlook at the outset of a case, the ethical issues and government benefit preservation, there's a tie in there. And really, I've been interviewed quite a bit about my book, and a lot of the questions I've got has been sort of about this, the idea of, what kind of liability is out there, what are the risks, and really for most law firms, the most risk exists in making a mistake in advising clients about what their options are at settlement, which is what the first part of the presentation will focus on. And then I'm going to spend some time talking about the government benefits that are needs-based. Rasa did a great job of talking all about Medicare, and I'll touch real briefly on Medicare, but really I'm going to focus more on Medicaid and SSI, which are the needs-based government benefits. So jumping in, the critical issue ultimately is making sure that your client understands what the issues are, legally speaking, the implications of the settlement. So a failure to advise the client is what exposes you to some potential malpractice, traps, and possibly a violation of the ethical rules. So the laws that impact settlement that are important are 42 USC 1396 P D4. This is the provision in federal law that exempts certain trusts from being countable for purposes of qualifying for needs-based eligibility. That's special needs trusts. Next is the Medicare Secondary Payer Act, which Rasa went into great detail and talked about, that Medicare has got to be a secondary payer. Next is Section 104A of the Internal Revenue Code. This is the part of the code that excludes from gross income personal physical injury recoveries and gives injury victims two different options when they sell their case. One is take a lump sum, and if they invest it on their own, they pay investment gain, but the actual lump sum itself is not taxable. And the second option, periodic payments via structured settlement, which allows clients to invest their settlement recovery in a non-taxable investment product, so they never pay any taxes, even on the investment gains. And then the last is constructive receipt, which is a tax doctrine, which if you trigger constructive receipt, it has implications for the injury victim in terms of their options. It limits their options, and also can have an impact on ultimately their ability to receive government benefits. So, the question ultimately for you to ask yourselves is, what are your obligations, and what do you do when you settle a case? Are you advising the client regarding public assistance preservation issues? Are you advising the client about the financial options at settlement? Both of those issues are of the law. That's why I was giving you on the previous slide the different legal citations, because the Internal Revenue Code has provisions that impact the financial side of the equation. Federal law provides for trusts that protect public assistance eligibility, and the Medicare Secondary Payer Act. All these things are things, in my humble opinion, that cannot be overlooked by a law firm without running the risk of potentially having a malpractice claim. The explaining the impact of a settlement on government assistance eligibility, the different techniques that can be utilized to protect eligibility. Those are, I don't think there's any question in anybody's mind that those things are things that must be done by the lawyer who represents the client. The financial side of it, I think, is sometimes overlooked because there is the focus on extracting the most value out of the case, which obviously is one of your primary jobs as a trial lawyer. But the problem is if at the back end there is not this discussion about the different options and the impact of it all, that client could wind up in a situation where they've mismanaged the recovery, they've lost government benefits, and at that point they might be looking at you as a potential target because if those issues were not explained properly, then there's going to be potential liability. So, under the model rules, you've got an obligation to explain matters sufficiently for a client to make an informed decision and consult with that client to make sure their objectives are achieved. Those two rules, I think if you read them together, really there's no question about this obligation, ethical obligation, potential malpractice risk of failing to advise clients. And if you take a look at this ABA study that is back from 2003, a large percentage of the ABA profile legal malpractice claims was related to personal injury practices and advice and settlement negotiation. Those two categories, if you put them together, were tied for first in terms of highest claims by activity in the study. So it's pretty clear that there is this potential malpractice risk associated with those issues at settlement. And the case that gets cited oftentimes about these issues is this Texas case, which was a medical malpractice claim for a birth-related injury that turned into a subsequent legal malpractice claim. And really at the heart of the legal malpractice claim was that the attorneys failed to preserve the government assistance and failed to advise the client about one of their options under the Internal Revenue Code, that the option to set up a structured settlement. And instead what happened was the monies were deposited into a specific type of trust in Texas, and investment of the settlement funds were done in a tax inefficient way. And so that was ultimately what served as the malpractice claim. And that's just an incredibly tough case to defend. And ultimately the case settled for $1.6 million against the plaintiff attorney. But even scarier, if you act as a GAL periodically, there was a $2.5 million settlement against the GAL for recommending approving this type of an arrangement. So you've got to really be careful about these issues, because in the, a catastrophic type case, there's a significant amount of damages potentially that can flow from failing to properly advise a client about these issues. So the damages that flow are easily quantifiable: loss of public assistance eligibility, loss of protection of settlement proceeds. A lot of states have statutes that specifically exempt certain mechanisms from legal process, like trusts and annuities. Losing a tax break like you get under the IRC for structured settlements. So that, in my mind, all of that means that ultimately you have a situation where you've got a duty to explain, because if you don't, there's damages that can flow from that. So being silent on issues that pertain to the law means that the client doesn't have an opportunity to exercise options available to them under the law, and then damages can flow from that. And all of this, I think, read together, including Grillo, is that you got to make sure that either you're advising the client about these issues or employing competent experts to explain these issues. Because if you don't do it, there's simply no one else that's going to do that. And I'm often asked about a threshold. Well, what if it's a relatively small settlement? Do these issues, are they really as significant? And the answer is potentially yes. For government assistance eligibility, a settlement of $2,000 or greater could disqualify your client. So it doesn't take a whole heck of a lot to cause an issue in your client's life. So making sure that you ultimately are aware of what these issues are and explaining them to the client, or having experts explain them to the client, is just it's the way to protect your practice. A lot of what we're talking about today are things that are ways to protect your practice. Make sure that you're doing the best that you possibly can for your clients at settlement, because you guys are experts at trying cases. You shouldn't be expected to understand the nuance of the Medicare Secondary Payer Act, or the hospital liens, or ERISA plans, or FEBA plans, or what I'm talking about, Medicaid and SSI, and some of these financial issues. It's just a lot for any lawyer to really have a firm understanding. And the book that Dan mentioned, I mean, it's, you know, a 200+ page book that talks all about these issues. And so it's not a simple, you know, cut and dry matter. These issues get into the weeds, and you've got to make sure ultimately the client truly understands what happens when they put that settlement check into their bank account if they don't do any type of planning. All right, so moving on, getting away from ethics and malpractice concerns, which are every lawyer's favorite discussion, we'll talk a little bit about government benefits, which is probably the second favorite topic of most lawyers. I know it's mine. So there are several different types of government benefits, and I wanted to just give a brief overview and compare and contrast, just because oftentimes these are confused, and you know, ultimately you really have to have some basic understanding of the distinctions to make sure the client gets the best possible advice about what to do. So at the top of the chart are the needs-based and income and asset sensitive benefits, which I'm going to talk all about, which is SSI and Medicaid. And then at the bottom are the entitlements, which are SSDI and Medicare. In most states, SSI and Medicaid are intertwined, and I'll explain that a little bit more in a second. With SSD, when you become disabled, you automatically get Medicare entitlement prior to retirement age. So it's a way to qualify for Medicare earlier on, which is what triggers these issues that Rasa had talked all about. And in terms of the needs-based government benefits, if someone is on SSI and Medicaid, there's not going to be a subrogation claim on behalf of SSI, but Medicaid will have a lien. It could be a Medicaid HMO, and the way you go about fighting a Medicaid lien is going to vary state to state. It's based on state law, since Medicaid is administered at the state level. So that's, you know, just a quick overview. Obviously, clients will typically confuse these benefits, so really best practice is make sure get copies of their cards and verify exactly what type of benefits they're getting, because some, for example, if they're not getting disability-based Medicaid, they could be getting it just purely based on financial need. Some of those programs have done away with asset caps after the Affordable Care Act, and so there's a lot of different things that you've got to look into or have someone on your team look into to make sure you know exactly what needs to happen once that settlement is consummated. So the importance of disability planning is really to make sure that you're providing your client with a framework to preserve their government assistance programs, which can provide for their financial support and medical care for the rest of their lives. Most settlements don't fully compensate clients 100%, so you need that fallback to be able to get government assistance eligibility. So this type of planning is what provides that framework, and also, you know, with the trust that I'm going to talk about, it creates a system of advocacy to make sure that that person's you know, life is protected in terms of how they live it, and you know, being able to live independently, and having the team that surrounds them that understands what the disabilities and public benefits require. All those things are why it's so incredibly important to do this type of planning for people that are disabled. And it's not every client that would need disability planning. It is only those that are disabled sufficiently to meet the definition of disability for the government assistance program. So if they are disabled and receiving SSI and Medicaid, if they're on Medicare, or if they're on Medicaid and Medicare, they're dual eligible. Those are the groups that you've got to be concerned about. If it's Medicare, it's the things that Rasa talked about. If it's dual eligibility, it's going to be the things that Rasa talked about and the things that I'm about to really get into in terms of SSI and Medicaid eligibility. All right, so Medicaid and SSI are, as I said, intertwined. In most states, if you get $1 of SSI, you automatically get Medicaid coverage. Both these government assistance programs are income and asset sensitive. SSI is supplemental security income, which is cash assistance paid to those 65 or older, blind or disabled. I think that I may need to update those figures. I'm not sure if those are the 2020 maximum, but it's in that ballpark. 780, 1,100 some odd dollars are the maximum amounts that someone would get under SSI. So a quick shorthand way to kind of figure out if someone's getting SSDI or SSI is, if they're single and they're getting $1,000 a month, they're getting SSD. They're not getting SSI because they're going to be way over the cap. For SSI, you don't have to have worked any quarters like you do for SSDI. And there is the asset cap that I talked about and an income cap. Asset cap is $2,000 if you're single, $3,000 if you're married. Income cap is going to vary by program. So SSI is a very small monthly benefit that in most instances are going to be paid to your client if they're disabled and they've not worked, or they're a minor child and have never worked. If somebody's worked, typically they're going to have enough quarters and they're going to be fully insured through SSD and they're going to get Medicare. SSI and Medicaid is typically for those that have not worked. Medicaid is just the basic healthcare coverage for those that are indigent. So the client who is on both those benefits and is disabled, that's where you want to consider establishing a special needs trust, which is that trust I talked about at the beginning of the presentation, 42 USC 1396 PD4. So if you don't do this type of planning and the client gets a settlement and deposits into their bank account, in the month they get it, it's income. If they've not spent it by the first day of the next month, it's counted as an available resource. So that's the problem. Ultimately, if the client gets the money, it becomes income in that month and they're going to become ineligible because they're going to have too much in the way of income in the month they get it and then too much in total assets in the next month. For most clients, they don't care about losing SSI because, as I said, that monthly benefit's really low. But at the same time, if they've qualified for Medicaid by virtue of being an SSI recipient, they've just lost their Medicaid as well by losing their SSI. So you really have to make sure that the client understands that the SSI benefit, if it gets terminated, they're going to lose their Medicaid at the same time. So let's talk quickly about the different types of trusts that are available to protect an injury victim's recovery if they're on Medicaid and SSI. First is what we call a D4A or standalone special needs trust. Those can be created for anyone that's disabled and under the age of 65, but you've got to be disabled within the Social Security definition of disability. The next is a D4C or pooled special needs trust. That can be created for anyone that's disabled of any age, so there's not an age restriction on that one. And then the last is a third-party special needs trust, which is usually set up in the context of a personal injury case where a fundraiser that's been done in the community to raise funds for the injury victim, or parents want to leave money to their disabled child. Third-party special needs trusts are for monies that are not the injury victim's own money. So the advantages of setting up this type of trust is that it keeps the government assistance eligibility intact. You get a professional trustee. Most of these trusts do have a professional trustee because most lay people just don't understand the SSI and Medicaid rules to be able to navigate them. Frankly, most lawyers don't even understand it. It's pretty complicated stuff. These types of trusts typically will avoid guardianship and annual reporting requirements, but it does depend on the court. And ultimately, this type of trust can pay for really anything and everything except food and shelter. So it's not limited to just medical expenses. It can pay for anything that improves that person's quality of life. The food and shelter restriction is related to SSI. If you pay for that for someone that's on SSI, then their SSI benefit gets reduced and they get really no benefit of it. So the disadvantages of these types of trusts are that the client doesn't have unrestricted use and access of the funds. These are sole benefit trusts, which means that the trust can only be used for the injury victim's sole benefit. At death, Medicaid has a right to be paid back for money that they've spent over that injury victim's lifetime. The only exception to that is third-party special needs trust. These trusts do add an extra layer of complexity, and ultimately the trust is irrevocable. That's required under federal law, so you can't simply undo this. So those are the disadvantages. In most instances, the advantages far outweigh it, or frankly, there's just no choice because Medicaid has to be retained. One thing to be aware of, two things actually, deeming and exempt assets. Deeming just means that money in the possession of, for example, one spouse is deemed to the other, or between parent and minor child. So if you have a settlement where a minor child had a medical malpractice claim, mom and dad make a consortium claim, the child's on Medicaid, that recovery, the child's recovery is put into special needs trust to keep the minor eligible for Medicaid. Mom and dad settle their consortium claim and get $500,000, and they take that money and put it into their bank account. They've just disqualified the child, and all the planning that was done is moot because the child is ineligible because mom and dad now have too much money because it's deemed to their minor child. Same thing between spouses. So you got to be careful of consortium claims when you have a situation where one of those people is on Medicaid. And lastly are exempt assets, because in a lot of instances, it doesn't make sense to set up a trust, and you can have a client spend down within the same calendar month that they get settlement monies and still keep their Medicaid in place. It can impact their SSI, but exempt assets are like a house, car. So a client, if they wanted to buy a house and buy a car, they could spend down all their money, get below the asset cap for that program, and not have a problem with regards to Medicaid. So not every case is going to require a trust, but the client needs to understand what their options are and understand about exempt assets. Pooled trusts are something that are used quite frequently in personal injury settlements because they are easy to establish, no minimum deposits, no age restrictions. There's an already established master trust that people join. All that has to be done is a simple joinder agreement. These types of trusts are managed by a not-for-profit, so the fees are lower. The trust will accept small trusts. So when you're out there looking for solutions for your client, if they're on government assistance programs, you want to evaluate these types of trusts because there's some really great ones out there, and then some don't really understand working with personal injury settlements. Most of the pooled trusts out there are familiar working with the elderly who are trying to qualify for Medicaid nursing homes, whereas some trusts are really focused on making sure that they understand and meet the needs of injury victims. And two, you want to evaluate the types of services that are available ultimately to the beneficiary through that trust. There are vendors out there like TrueLink and Team that provide services to pooled trusts that make the trust way more attractive. And ultimately, you want to look at their fee structure. A lot of trusts don't disclose their investment expense. They'll just disclose a trustee fee, which might look low, but they might have a 1.5% investment fee. And then lastly, the retained funds policy. So what happens is at death, under federal law, the not-for-profit can retain assets if what is owed to Medicaid is more than what is left in the trust. Remember, I said these trusts have to have that federal payback. So you want to investigate what the retained funds policy is, because in a lot of instances, it's 100%. And then there's some trusts that are as low as 10% or a fixed amount. So you really have to investigate that to know ultimately what the client is exposing their recovery to when they pass away. One of the last things about the planning side of things for people that are on Medicaid and SSI is ABLE accounts. And these are limited because they can only be created for people that are disabled prior to age 26. And there are significant limitations on how much money can go into these accounts. But typically these are used these days in conjunction with a pooled special needs trust, or a structured settlement to fund these. It's a great planning device for the right situation. You just have to have somebody that was disabled at a young age. So with that, I'm going to transition quickly to talk a little bit about Medicaid liens. Medicaid liens, the process by which you go about reducing really is going to vary state to state, but you do have two incredibly important federal U.S. Supreme Court cases that you should be aware of. First is Allborn, and then subsequently the Wass versus EMA case, which is from 2013, which affirmed Allborn. But basically, at the end of the day, what the Supreme Court has said is that the state's third-party liability recovery statutes are limited by the federal anti-lien provisions, and basically the holding of Allborn ultimately and Wass is that Medicaid can only recover from the past medical expense portion of a recovery, and the states have varied statutes, so you really have to look at your state statute and what the process is. For example, in Florida, and I handle these through my law practice, where I go to the Division of Administrative Hearings and argue why a lien should be reduced under Allborn. That's because our state statute has these very specific provisions. Many do not. So you really want to make sure that you're arguing the case law to the Medicaid agency to get them to reduce pursuant to Allborn and Wass. But at the crux of that is that it does create basically a equitable distribution type of argument based on the full value of the case compared to what was actually recovered, creating a ratio by which you would ultimately argue the reduction of that Medicaid lien. So last thing I wanted to talk about, just because we're talking about this idea of taking care of the client, advising the client, and really everything that we've talked about today, there's all these complexities that can cause delays in terms of getting the ultimate resolution and money distributed to the client. One of the ways to avoid having a time crunch is to establish something called a qualified settlement fund. And it's not something that is really common knowledge outside of mass tort cases, but because these things are commonplace in mass tort, but used a little less frequently in other settlement contexts. But basically, this is a mechanism to avoid triggering constructive receipt. So constructive receipt, I talked about early on when we were talking about the potential malpractice risks. Here what this does is it ultimately gives you a holding tank for the settlement proceeds without triggering constructive receipt. And really the only way to avoid triggering constructive receipt is to leave the money with the defendant, which most of the times that's not attractive. You want to get the money quickly from the defendant, be able to take your fees and costs, but then deal with all these issues that we're talking about without having to wait for the money to be paid by the defendant and some of these decisions to be made. So all a QSF is it's a temporary trust that's created pursuant to Treasury regulations found at 1.468B-1. And when you settle a case using a qualified settlement fund, it's just like any other settlement. It's like a cash settlement. Even if structured settlements are involved, all you would do is indicate in the release with the defendant that the consideration for the settlement is a payment made to the qualified settlement fund instead of to your trust account. The way the regulations are written for QSFs, it can be used in a mass tort situation or a single plaintiff situation, and it gives you that time to do the planning and resolve liens, deal with Medicare Secondary Payer Act issues, deal with SNTs, Medicaid SSI, all while avoiding that triggering of constructive receipt. The drawback to doing it is it does require court approval and there's some additional expenses, but it is relatively inexpensive, and in the right case, it makes a heck of a lot of sense. In terms of how these are set up, basically, as I said, you do a cash settlement between the plaintiff and defendant, do a normal release. The settlement check gets made out to the QSF. You've got to have a court create this. So you have to obtain an order creating the qualified settlement fund. And then basically the funds sit in that qualified settlement fund until allocation decisions are made, liens are negotiated and satisfied. If there's government assistance, setting up the special needs trust or an MSA or both. If there's financial considerations like a structured settlement being contemplated, those can be decided upon. And then once all of that is done, then the QSF can terminate once all the funds have been dispersed. So these are some really great situations where you might want to implement a qualified settlement fund if you've got multiple claimants and allocation issues between different claimants. If you've got multiple layers of coverage and you want to aggregate settlement monies. I see cases all the time where they've got $100,000 settlement for policy limits, but there's 2 other defendants out there with millions in coverage. Kind of hard to do a plan with $100,000 recovery or the first layer of coverage settling out when you know there's going to be multiple layers, but you don't know how much. When there's complex lien resolution issues or government benefit planning issues or structured settlements involving a client or an attorney, all the above, all those things are great reasons why you might want to implement one of these. So the last thing I wanted to touch on was this idea of consult, advise, document. This was something that Rasa mentioned during her presentation. And really, if you take nothing away from today, you've got to make sure that your client understands all of these issues, that you're consulting with your client, and then ultimately having them consult with experts such as Synergy, making sure that the client does get the proper advice, and then documenting your file. That process, if you are not doing it within your law firms, then you've got the potential exposure out there, and you want to make sure that you limit that to the most infinitesimal amount that you possibly can using those methodologies. That's my contact information. If you've got any questions about anything that I talked about today, feel free to reach out. One last thing, that's a picture of our entire team from our last annual meeting, and I always like to include that because I think it's important that you understand that we have a team that's dedicated to fighting for your client, who's dedicated to making sure that we do everything possible to protect and improve the quality of life of the injury victim. It's our mission, it's what we care about, it's our purpose, and every person in our organization is dedicated to doing whatever it takes to make sure that we deliver on that mission, because it's incredibly important to us personally and professionally. I can tell you from myself, having been involved in a pretty serious accident, I relay that to everybody so they understand exactly what injury victims go through, and we continually bring that to our meetings when we have our all hands, just so people understand the importance of the mission and who we serve and why we do what we do every day. And hopefully that comes through in these presentations, because we do want to make sure ultimately that you guys have that firm understanding of the issues that are going to protect that client.
Absolutely. Thank you, Jason. I really appreciate Jason kind of landing the presentations on the passion of Synergy, and just would like an opportunity to reiterate that, having been in this business for a long time, we certainly understand the realities of a personal injury practice, right? And the lawyers and firms on this call, you're the ones doing the work, you're the ones taking the risk, you're the ones funding the costs. And then the minute you have a victory for a family that so badly deserves it, all of these issues pop up and all these lien holders pop out with their hands out, right? So Synergy was an organization built specifically for that purpose, to make those lien holders, public benefit holders fight as hard for their money as you fought to get it. We believe that's only fair, and we're passionate about being experts in this space, being expert partners that can make your law firm more efficient. And in doing this, having these wins for the families that you work so hard for. And it's what it's all about, and it's why we do what we do. In addition to having the opportunity to introduce the brighter members of my organization, I head up our business development team. If you've heard anything in today's presentation and you'd like to dig a little deeper and learn more about utilizing Synergy as an expert partner, I would love to be part of that conversation. My email is dan@synergysettlements.com. We've got a robust team of business development leaders, and I would love to connect you with the person handling your geographic area, making sure that we're accessible and a resource both down the stretch Q4 as things tend to heat up, and then going into next year. What we've heard from our customers is now more than ever, law firms are looking at ways to be more efficient, and we would certainly love to be part of that solution for you. With that, I will go to the questions that have been posed thus far to the chat box. And I encourage you to keep bringing those questions should you have them. And if we run out, we'll get crazy, unmute the phone lines and see what happens. So question number 1, explain why Medicare opens multiple case ID numbers for the same accident for a beneficiary with a liability claim and a UIM claim. We disclosed the tort and UIM settlements on the case ID we knew about and satisfied the final demand from CMS and dispersed monies. Months later, we received another final demand letter on a different case ID number, not known to us on the tort recovery. What to do short of paying the new demand? Is Medicare stopped from asserting a second lien since we disclosed both settlements on the first case ID number to CMS? Rasa, thank you.
All right. Thank you, Dan. So unfortunately, this is one of those very frustrating, ridiculous things that Medicare does. I mean, you disclosed both settlements. There's really no reason why they would have opened a second claim, except for the fact that Section 111 mandatory insurer reporting obligation applies to both the tort primary payer and the UIM payer. So Medicare received a report through Section 111 of both of these settlements, even though they're for the same accident date, and they're never going to cross-reference or sort of look at something in a holistic manner. So that is the reason why they open this. But what you can do is you can certainly, and our team has been very successful in reaching out to BCRC to let them know that this issue has already been addressed. These payments have already been taken into account in this particular case ID, and then they wipe it out. So there is hope. You shouldn't have to pay that demand, but this is something that Medicare unfortunately does far too often. The key though is not to, you have to take care of it sooner rather than later. Once it gets to Treasury, then it's really much more difficult to address the situation.
Thank you, Rasa. Michael, question for you. I believe there was a comment that we received on the Texas lien statute, and you'd like a chance to make some clarifying remarks. You're muted. I can give you time to think if you want me to go to another question.
For some reason, there we go. For some reason, it wasn't unmuting. Yes, someone pointed out that I misspoke, and I really appreciate that. First and foremost, that is very helpful. The Texas lien statute I mentioned is one of the few that does not include a reference to reasonableness. I was incorrect. It does not, in its primary section, like most lien ordinances, limit the lien to reasonable charges. What it does is all the way down out of that entire section, further into, that was section 55002. In section 55004, it says that this lien does not include unreasonable charges, which is a very unusual way to do it, but it still comes to the same conclusion. And presumably that is the reason that the Supreme Court then solidified that reasonableness requirement instead of creating it, as I said. So there is a reasonableness requirement in Texas. It is in both the statute and in the Supreme Court case law.
Thank you, Michael. Next question. Do you have any standard language for a closing statement when a client refuses to do a special needs trust? Jason, I'll turn to you on that one.
Yeah, what I would recommend is having the client sign a specific acknowledgement. We can provide that to you. You can email me at jason@synergysettlements.com and I'll send it. In the closing statement, what I recommend is doing something that's pretty innocuous or general, just that receipt of settlement proceeds can impact eligibility for government assistance programs, something that they're acknowledging, and then if after they've been educated they refuse to follow the suggestions of an expert in terms of setting up a special needs trust or setting up a Medicare set aside, then have them sign something specific. And one of the things that we do with Medicare specifically, we don't do it with Medicaid because it is state to state, but with Medicare, we offer our Medicare expert case evaluation, which gives the client that consultation and then gives your firm that acknowledgement that the client signs that they've been advised about those issues and they understand, demonstrating that they have made an informed decision, which is, was one of the main points of my presentation on the ethics portion, is making sure that the client has the education they need to make that informed decision.
Thanks, Jason. Michael, another one for you. You mentioned the difference between liens and debts. Could you elaborate on the difference and what it means to us as plaintiffs' lawyers?
Yes. This is my liens, the hospital liens and the provider liens are the only liens that fall into this category. In all the other liens that you heard about today, there is an obligation that is created by a settlement, right? You don't owe your health insurance any money back if you didn't get a settlement. So that settlement creates the lien. That's different in my world because here there's a debt regardless of whether you get a settlement. So you had your client had a hospital debt because they received hospital services in the example of hospital liens. So not only do they have that debt, but these statutes or these contracts or ordinances also secure that debt to the settlement. So that is the lien aspect. So there is a big distinction between liens and debts, and sometimes, especially the more savvy hospitals, will negotiate them somewhat separately or require the negotiation of them somewhat separately by telling you while you're negotiating, well, okay, we will take into consideration all these equitable concerns that your client wasn't made whole, or that there is a limited settlement, or that there's a lot of other obligations, and we'll release our lien accordingly, but we're going to maintain a debt balance. And in so doing, they can then pursue that debt balance against the patient. So this is important to you as plaintiffs' lawyers because your ethical obligations turn on the lien aspect, not the debt aspect. The ethical requirements in, I believe, all states, certainly all that I've reviewed that aspect deeply, require you to hold any liens in trust. They obviously do not require you to hold all of your client's debts in trust. Any creditor that your client may have does not have a claim to that particular settlement or those proceeds. Instead, they merely have a debt collection opportunity against your client. So making this distinction understood by your client so that they can decide whether or not to satisfy debts, mere debts out of their settlement proceeds is an important aspect of what Jason was talking about, explaining all of the options and documenting them to protect yourself.
Thank you, Michael. Next question. I'm dealing with a self-funded ERISA and a limited 100K policy. Lien is over 200K. So far, I've only been able to, pardon me. So far, I've only been able to negotiate a reduction for them to take $37,500. What is a realistic settlement of their lien? Teresa, I'll give that one to you.
Well, definitely a lot of unknown factors to be able to answer that question. So if it is an ERISA self-funded plan that has that policy language that is really bulletproof, unfortunately, they could be entitled to the entire amount, the entire $100,000. We have seen a couple of those that take that really hardcore position. Luckily, most don't and try to act like they're being equitable. Three-way split is the idea of equitable, but most lien holders, those recovery vendors, depending upon who they are getting away from even that. And it sounds like at 37.5 that they're almost refusing to get to that place because they have found that a lot of attorneys are comfortable in that place, that they will agree to do a three-way split. So to answer the ultimate question of what's a good number to resolve, super hard to answer because I don't know what that policy language is, don't know what recovery vendor it is that we're dealing with, really even what the other equitable factors are that even though they don't legally have to take it into consideration, it still is a consideration. So lots of different things, but I think a lot of times if you can get to that three-way split place, that's considered good. It's not good to me, but it's considered good by a lot of plaintiff attorneys. So could certainly take a closer look at that one though. If you want to reach out to Synergy, we could take a closer look.
Next question. First of all, thank you to all the speakers. Great job. Never skip the compliments, right? Is there a disclaimer or agreement a client can sign at settlement acknowledging their refusal to have an MSA? And if signed, does that protect the attorney? I.e., treating physician states future surgery likely, and client says there's no way they'd ever have the surgery and don't want funds set aside. Rasa?
Thank you, Dan. I believe that Jason touched upon this sort of waiver in the context of the Special Needs Trust. And there definitely is an acknowledgement or a waiver that we can assist with a MECE consult, where we actually explain what the various Medicare secondary payer compliance issues are, what Medicare might possibly do if the treating physician is recommending surgery, but the person doesn't want to put aside any sort of funds to prevent a cost shift of these expenses to Medicare. And once you have this document that advises that Medicare's interests have been discussed with the claimant plaintiff, that the plaintiff has voluntarily acknowledged the potential risks and the potential issues, and that they sign off on this, I mean, really, there's nothing else you can do as an attorney other than advise your client after consulting with an expert and document your file. So there is such an acknowledgement, and by having the discussion with your client, I believe that you can definitely show that there was no attempt to cost shift any expenses to Medicare. Your client was properly counseled. There is no potential malpractice action. All you can do is inform and advise and consult with experts.
Thank you. Next question, can you discuss the difference between subrogation and reimbursement? If a plan has a subrogation provision allowing it to exercise its rights against a tortfeasor, but does not have a right of reimbursement, does the beneficiary have to directly repay the plan, or can they defend it against it on the basis that the plan only has the right to pursue the third party, not the beneficiary?
That's an
Teresa.
excellent question.
Excellent question. And by the way, I'm glad that we finished early because these are some long questions. You guys are asking some good ones. Keep them coming. Go ahead, Teresa.
Yeah. Definitely. So super good question. Something you should be looking for in every ERISA policy, because there are some that do just this, that give the plan a right to subrogate. McCutcheon, the U.S. Supreme Court case of McCutcheon, says that it has to clearly outline its rights of recovery, who it's recovering from, and all of that. So if it only has a right to subrogate, the term subrogation means standing in the shoes of the injured party and looking directly to the tortfeasor. On the other hand, reimbursement is once your client gets the settlement funds, then they now have a duty to reimburse the plan. So I do a lot in other webinars talk about the distinction between those 2 points. So yes, you have the ability to defend that. I know at Rawlings, they would train their people to look for that. And if it only allowed subrogation, then they would tell them they were not allowed to seek reimbursement from the injured party. So again, don't know which vendor this is, but that is something that's crazy sitting in the Synergy seat as compared to sitting in a Rawlings chair, is that each one of these recovery vendors do things differently, and what they focus on and what they interpret, what they interpret as an allowable interpretation of the law is so varied, and I'm sure that all the plaintiff attorneys here on the phone have experienced that as well. But yes, please do defend that. They do not have a right to recover directly from the injured party.
Thank you, Teresa. I want to give a very fair warning to anyone listening to the call on a side browser and maybe being on your phone. We are now going to unmute the phone lines of all our attendees in case anyone wants to ask a question live. So I don't want to catch anyone in a conversation accidentally. So consider this the final warning, and then I'm going to ask our team to unmute the lines, and we'll take any live questions that any of the attendees might have. And again, thank you very much for spending this time with us and giving a chance to present this information. Not sure if they're unmuted or not.
We are unmuted.
It's official. Well, we'll hold the line for a minute or two. And if not, thank you again. We look forward to working with you and being an expert partner with the families that you represent.
I have a question.
Please.
Don't know if you can hear me or see me. And it ties in with the waiver. I have a situation, just settled the case It's much less than we wished for, but due to policy limits, I have a Medicare and Tricare recipient. And so I'm trying to be very cautious. In fact, I'm sitting in on this webinar just because of that case, because I knew that I didn't know enough. But because of the limited settlement funds, I'm concerned that using a professional service, which I think I need you guys in this situation to cover myself, that you're going to have to dip into the settlement proceeds. And how do I explain that to a client? So what is the cost of your services to consult with the client in my case and to advise them of their rights and the possibility of having to set aside some funds?
Sure, absolutely. And who am I speaking with?
This is George Hunter out of Florida.
Hey, George. Oh, thank you. Where in Florida?
Tampa.
Oh, I'm in Tampa as well. I can just come by the office and answer if you'd like. Or we can finish up here.
Actually, I'm in Riverview to be more precise, but yeah.
All right, a little more of a drive. So George, I'll handle the broad pricing question, and then we can talk about your case and specifics. You know, Synergy has a pricing structure that is based on our results, right? We charge a 15% of savings that we achieve on behalf of plaintiffs. But the most important part of Synergy's pricing is our automatic cap. And what our automatic cap does is it automatically caps our fee, no matter where that comes out based on the reduction, at 15% of your client's net. And there's a real important reason for that. And there's really two. The first being, as an organization, we want to be certain that every single plaintiff that is involved with Synergy is better off as a result of our involvement. And often when we are needed the most is when the lien amount exceeds the settlement amount, sometimes by multiples, right? And in those cases, our traditional fee structure would not make sense. But by having that cap in place, you know that no matter what, when we hit a home run on the lien holder, that the client will benefit as a result based on that cap. And then additionally, in our effort to be a efficiency partner to the firm on an ongoing basis, we never want the hiring of Synergy to be a math problem that requires you to pull out a calculator and decide if the numbers make sense for Synergy to go to work. We want you to know that you have an expert team behind you and that no matter where the numbers land, our cap is going to make sure that every plaintiff is better off for our involvement. Does that make sense?
Absolutely, it does. It's good to know that. So Dan, I guess I'll be reaching out.
Perfect. Dan at Synergy Settlements. Look forward to speaking with you.
All right, thanks a lot, guys.
I think too, I just want to make sure, because I think your question was also pertaining to the consultation, because we do that on a flat fee basis for Medicare. That Medicare expert case evaluation that I mentioned is $1,000, which includes the documentation for your file ultimately. So, you know, with lien resolution, that's the pricing that Dan described, but for that Medicare expert case evaluation, it's a flat fee based service.
Right, and you know, just sort of to pick up on the other question of how would you explain this to your client in terms of what are they getting post-settlement? So in exchange for the fee for the Medicare expert evaluation, they're going to get documentation that specifically outlines that we are considering Medicare's interest. We're going to determine, based upon the limited facts which you gave me, for example, that the settlement does not fund future medical. We're going to reference the Stallcup memo that allows plaintiffs' attorneys to, actually act as attorneys and consider whether there's any attempt to cost shift injury-related expenses to Medicare. And so this evaluation letter would provide support, against Medicare denying any services. This would be a way to rebut any perception that there was any attempt to cost shift injury-related expenses to Medicare.
Thank you, Rasa. Teresa, another one for you. If a child is receiving a settlement, can you discuss the fact that the medical expenses are a parental obligation? Therefore, does giving the money only to the minor allow the plaintiff to argue the parents are getting no money? Therefore, the ERISA lien does not attach to the proceeds of the minor because the minor, under many states, cannot by law recover in their name for past medical expenses.
Yes, that's a lot. But yes, there are some arguments to be made there regarding minors. Definitely depends on state law. We've had a good number of those cases that we've handled where there's liens, and we make those similar kind of arguments based on the law of the state. Even if it's an ERISA self-funded plan, we're still arguing whatever that state holds as the law for a minor receiving a settlement. I can't say that we've knocked every single one of them out of the park, because sometimes the lien holders on the other side are really stubborn and difficult, but I know we've definitely got some major waivers in that exact situation. So totally depends on state law. Would also say for an ERISA self-funded plan, it depends on the policy language. So there are times where the policy language will say a plan participant is responsible for XYZ. Well, if you go to the definition section and you look up plan participant and it says employee, then that is not covering that minor child. It's not covering the dependent spouse. So that's another place where the policy language can really help you out. So I would recommend looking there first, because that is definitely the strongest argument for that situation.
Thank you, Teresa. Any other questions from any of the live attendees? All right, hearing none, feel free to reach out to us in the email contact information shared. Mine again is dan@synergysettlements.com. Also tons of information on our website at synergysettlements.com. Look forward to being a resource to the families you represent, and thank you for your attendance today.
Thank you.
Thank you.